Hello. To continue our conversations about arbitration, today we're addressing arbitration in the matters of vis cachés or latent defects. We'll probably touch the greater topic of real estate arbitration later on. Today we're concentrated on exactly latent defects because there are many, they are very often to appear in a caseload and in reality between the buyer and seller, particularly when it comes to some immovable property, the real estate. And here is where the problem lies. Very often, I would say mostly, the issues of real estate are the amounts in question with the issues of real estate are sort of like borderline. If you go to the Court of Quebec or a Superior Court with those issues, the amount that you potentially might spend is equal or greater uh, in comparison to the amount that is needed to compensate or to rectify this latent defect. Of course, if you're talking about like 150,000, 200,000, uh, something with the foundation, the walls, the roof crumbling, or something like that, you're probably going to the appropriate court is a reasonable approach. But when we're talking about something like 20,000, 30,000, uh, it's less obvious. When it's about 5, 7, 10,000, then the small claims court is there, of course. And if the amount is lower than 5,000 in just many courthouses, you'll end up with arbitration in small claims anyway. But what if your claim, the amount in question, is greater than 15,000, but lower than, let's say, like 50,000, more or less? In such a situation, arbitration has its advantages. So first of all, it's faster. And if you're ready to litigate for a year or two for 100,000, 200,000, not entirely clear if you're ready to go for a 1 to 3 year litigation if it comes to 20,000, 25,000. In comparison, arbitration is finished in weeks, sometimes like 1 to 3 months even, but still significantly faster. Second, one of the reasons why regular judicial approach and litigation is so costly because there are many quite strict procedural elements in there that should be observed, which are usually more relaxed in arbitration process, particularly because arbitration is done by agreement. So both parties should agree on the arbitration itself, on the personality of the arbitrator. And very often, the arbitration agreement has specific references to those procedural matters, which to a certain extent can be attenuated. And finally, when you go to court, you don't choose your judge, you get what you get. When it comes to arbitration specifically, because of this consensual nature of the very process, you can agree together, of course, or if there are many parties, like altogether, uh, on the personality of the arbitrator or several arbitrators sometimes who would have this specific expertise with regards to real estate and particularly with respect to latent defects. So altogether, you will have a faster, less expensive, and more on point decision. And when it's done, because usually arbitral decision award is final, you won't need to bother about spending additional time waiting for possible appeal, and if there is an appeal, just to go through it and so forth. So you save time, money, and level of stress because of that. In view of like not so significant amount in comparison to those greater amounts that are more susceptible to go for the full scale litigation. Though you still can go for arbitration with those, of course you can. The only caveat, as you understand, is to get to an agreement with the other party. And it's possible, usually, if both parties are interested in a faster and less expensive resolution. Thank you and have a nice day.